Hernandez is present in court. Will the parties please identify yourselves for the record?
Good morning, Honor. Patrick Hagan from Commonwealth.
Good morning, Teresa Anderson for the Commonwealth.
Good morning, sir. Jose Baez on behalf of Aaron Hernandez.
Ronald Sullivan on behalf of Mr. Hernandez.
Kenny Vaughn on behalf of Aaron Hernandez.
Sean Medina on behalf of Aaron Hernandez.
George William Terry on behalf of
All right, counsel, at the close of the Commonwealth's case yesterday, the defendant moved for a required finding of not guilty. By agreement, we postponed argument on that motion to permit us to deal with yesterday's witnesses, understanding that when argued, the court would be ruling based on the state of the evidence at the close of the Commonwealth's case. Mr. Sullivan, you agreed to postpone that argument till this morning, so I'll be happy to hear you on it now.
Thank you, Your Honor. We submit on the papers with respect to most counts. We would like to be heard with respect to the intimidation of a witness charge. So we want to make a couple points with respect to the intimidation of a witness charge. It's our position that the Commonwealth has not made out a case sufficient to move on to the jury in this regard. As Your Honor knows, there are 4 requirements that must be met in order for a witness intimidation charge to go before the jury. One, that the target of the intimidation was a witness or a potential witness in a criminal proceeding. 2, that the defendant willfully endeavored or tried to influence the target. 3, that he did so by means of intimidation. And 4, that he did so with the purpose of influencing the complainant as a witness. And I want to focus on a couple of these elements, Your Honor. The first element, that the target of the alleged intimidation was a witness or a potential witness. So, of course, clearly, Mr. Bradley was not a witness. So the question is whether he may be properly considered a potential witness. The relevant law in the area, Your Honor, is ask the court to determine whether or not it's reasonable that at the time of the intimidation, the target would likely become a witness in what would be or what would become the offense. And what's clear on this record, Your Honor, is that Mr. Bradley had absolutely no intention whatsoever of cooperating with the government at any stage up until long after the 13th of February 2013. Indeed, Mr. Bradley testified that he was not going to testify, had no intention to testify. There was nothing about their relationship that was suggestive that Mr. Bradley was going to provide information to the government. And the irony here, Your Honor, is that what changed that ultimately was the shooting. According to Mr. Bradley, it's the shooting and additional factors after the shooting that convinced Mr. Bradley to become a witness or a potential witness. So it's very similar to other areas like, Fourth Amendment law, for example. It's an after the fact justification. An after the fact justification cannot be used to serve as a basis for the claim that Mr. Bradley was a potential witness. Now, even if the court were to find Mr. Bradley to be a potential witness, what's important here with respect to intimidation of a witness is that this is a specific intent crime. That a threat or an assault occurred in and of itself is not sufficient. That is to say that there was an assault before some sort of proceeding, criminal proceeding, is wholly insufficient as a matter of law. Rather, the assault has to have been for the purpose of influencing the target, the purpose of influencing Mr. Bradley in his role as a putative cooperator with the government. Here, Your Honor, I'll point your honor to Rosario. It's 83 Mass Appellate Court 640, and also to McCreary, which is 45 Mass Appellate Court 797. McCreary and Rosario point out that normally there's absolutely no question as to intent. That is, someone says, if you testify, I'm going to do this. So the threat, there's a direct threat in relation to the testimony. Here, it's different. In cases like McCreary, for example, the court pointed out that in some cases, it is a stretch of the imagination to infer that the defendant was attempting to influence the target as in the target's capacity as a witness. So the unlawful influence, there has to be an intent to unlawfully influence a witness qua witness. That is, the witness in the witness capacity. So normally, the courts say it's straightforward. But in some cases, you have to use inferences. This is the precise sort of case where one has to infer that an assault was intended to silence Mr. Bradley as a witness. And in order for the court to determine whether this inference is permissible, the Massachusetts courts have articulated place, time, and circumstance. Place, time, and circumstance. You see this in McCreary as well as Rosario. Place, time, and circumstances. That is, the defendant has to do or engage in the assault in a particular place, at a particular time, and in a set of circumstances that is suggestive that the defendant is doing this for the express purpose of influencing a target in the target's capacity as witness. In many of the leading cases, the place, time, and circumstances limitation voted in favor of the government's claim. One case, it was right outside of a courthouse, right before a hearing. In another case, the defendant said, don't let me see my face on the news. This was a robbery of a store. And, you better take care of those cameras. Don't let me see my face on the news. Here it was clear that there was the place, time, and circumstances limitation suggested that there was, in fact, an intent to influence the witness as witness. In this case, we have the opposite. There is no evidence that Mr. Hernandez did any act for the purpose, again, specific intent crime, for the purpose of influencing Mr. Bradley as a potential witness. The evidence we have is voluminous to the contrary. That is, Mr. Bradley's own statements say that they were friends, that there was no discussion about the case in terms of Mr. Bradley cooperating with the government. Absolutely nothing. There was one statement viewing the evidence in light most favorable to the government. There was one statement, and one statement only. Mr. Bradley testified that he told Mr. Hernandez, well, if there are undercover cops here, that is because of that stupid expletive stuff that you did in Boston. So you take those 5 or 6 words. That's the state of the evidence. Now, what is it about those words that suggests that that was a predicate to silencing Mr. Bradley as a witness. There's no evidence that Mr. Bradley said those words and then said, I'm going to go and cooperate with the government. To the contrary, on cross-examination, Mr. Baez asked Mr. Bradley, well, are you suggesting that this is why you were shot by Mr. Hernandez? And Mr. Bradley says, no, I'm not. I'm not saying that that is the reason. I don't know the reason. And this is important, Your Honor, because there is a universe, again, viewing the facts most favorable to the government, there is a universe of reasons why this happened. And that it happened in order to silence Mr. Bradley as a witness seems not to rise to a level sufficient to allow this to go before a jury, particularly in light of Mr. Bradley's express contrary statements. So, in the end, our point is this, Your Honor, that for intimidation of a witness statute to attach on any criminal defendant, there is an express mens rea requirement. The mens rea requirement is purpose or specific intent, to use the common law jargon. Here, the government has produced no evidence we submit to show that there is specific intent. Again, it's not a general intent crime where you intend the ordinary and probable consequences of your action. This is a specific intent crime where the government has produced no evidence to show that Mr. Bradley had the specific intent to intimidate Mr. Bradley as a function of his status as a witness. Now, the court in McCrary recognized that there is a meaningful distinction between a threat or an assault for something, for anything, and a threat intended to influence a witness. It is only the latter that permits criminal liability to attach. Here, the statement, it's because of that stupid expletive stuff you did in Boston. Again, taking the facts most favorable to the government for purposes of this motion, it could have been that the receiver of those words were angry. It could have been that it was insulting. It could have been that it made the receiver of those words furious. But there's nothing about the, quote, time, place, and circumstances in a bar, a Tootsie's, in a club, where the two of them traveled as friends to Florida together. There's nothing about the place, time, and circumstances suggestive that Mr. Hernandez was trying to influence Mr. Bradley as a witness in those cases. And there's one last point that, again, time, place, and circumstances. If the government's evidence is to be believed, then they're suggesting that Mr. Hernandez was attempting to get rid of witnesses because of an act that he committed in Boston. If their theory is to be believed, then they'd also, the jury would also be required to believe that Mr. Hernandez created additional witnesses in Florida by engaging in an act in front of others inside of a vehicle. So on the place, time, and circumstances register, there is insufficient evidence that the alleged intimidation of a witness was because of that person's status as a potential witness.
Anything further?
No.
Okay. Commonwealth, do you want to be heard?
Yes, Your Honor. The Commonwealth presented sufficient evidence on the witness intimidation charge to go to the jury. As Mr. Sullivan pointed out, there is one statement, and that one statement alone is enough to take this case to the jury and for the jury to decide and weigh against the cross-examination and weigh against all of the could have been, should have beens that it may mean. I think the other critical distinction here is that the witness intimidation statute isn't so much what the witness himself believed, but it's what the defendant believed. It's what the defendant's intent was. And the one statement that Bradley says and the defendant responds evidences the defendant's intent. A reasonable jury could find that it evidences his intent to silence the witness and to dissuade him and, in fact, silence him completely from any future testimony or proceedings.
All right, I'll take the motion under advisement to review the cases the defendant is relying on, most significantly McCrary and Rosario. If the charge is put to the jury, the shooting here occurs in California, in Florida. Is it appropriate to instruct the jury that they are not determining that crime, that is, a shooting itself, but they must connect it to the Boston case, which is the so-called criminal proceeding or investigation? It seems to me that's appropriate, just to clarify and deal with the jurisdictional issue. It is not an element directly, but it's kind of a sub-element to the requirement for a criminal proceeding of some sort. Defense, does that make sense to you?
Yes, Your Honor.
Commonwealth?
Yes, Your Honor, I might just suggest perhaps the fourth section of the statute would be appropriate to just tell the jury that the prosecution under this section may be brought in the county in which the criminal investigation, grand jury proceeding, or trial, that is the Boston case, or the county in which the alleged conduct constituting the offense occurred.
We will submit something, Your Honor, in the unlikely event this charge goes to the jury. We'll submit an instruction for Your Honor's consideration.
Should I stay around waiting for it?
We will get right on it.
All right. Now, I've received yesterday the Commonwealth's request for instructions. I received this morning, and quite belatedly, the defendant's requested instructions. And from the two of them, I'm going to craft the instructions that I will be giving. Ms. Anderson, thank you for preparing a chalk. I see that following your presentation of the chalk, the defense has filed a motion for jury instruction chalks. Mr. Leontier, do I understand you did that in response to the Commonwealth's submission of a chalk?
Yes, Your Honor, and I do understand the Commonwealth chalk is provided by the SJC.
It's required.
But we think the chalks, which absolutely mimic the standard, the standard jury instruction, simply in a little bit of an outline form, would be helpful to the jury and not neutral.
All right. Mr. Sullivan, do you have any comment on the chalk as provided by the Commonwealth? It does seem to track the SJC's requirement in their appendix to the model homicide instructions, simply laying out the elements for each crime or theory underlying the charged offense.
Judge, on the first page it is consistent. The second page, I think the Commonwealth agrees it's not necessary or required. They can answer.
It's not required. It seems to make sense if we're giving one elemental chart as to one charge, we might as well do all.
I'm literally just saying this, Your Honor. No objection.
All right. Then I'll plan to make use of that chalk. And as to the defendant's motion for instruction chalks, that is denied. Mr. Hagan, the Commonwealth, in its written instructions, had proposed a joint venture instruction. Do I understand that you've given that some thought?
We would withdraw that request, sir.
All right, so no need to reference joint venture in my instructions. The defendant has filed some motions this morning. One is a motion in limine to exclude mention of Alcorn, John Chicago Alcorn, as possessing the murder weapon. Mr. Hagan, we did not hear from Jolene Ramos, did we?
We did not.
And Jolene Ramos was the individual who attributed the contents of the trunk to Chicago.
In one of her various statements, yes.
But not before this jury.
No.
Is there any evidence that Alcorn, in fact, had any connection to the trunk of that Honda Accord?
There is evidence that he has a substantial connection to Ms. Diaz-Ramos.
He lives across the street and down the block.
And
they're friends.
From their childhood, yes.
Yeah. All right. With regard to the motion to exclude any argument that Alcorn, in fact, possessed the weapon, what do you say to that?
Your Honor, I think the Commonwealth is entitled to allow the jurors to make reasonable inferences, and one of those reasonable inferences would be that where a woman who is found with the murder weapon is that close to an individual who has substantial ties to 114 Lake Avenue, including testimony that he has been to that address on occasion. The Commonwealth is entitled to ask the jurors to make reasonable inferences that that is the connection to 114 Lake Avenue, and that is the connection to the defendant.
Well, that's different from saying that Alcorn possessed the weapon and left the weapon in that vehicle.
Right, I don't think we're not going to argue that. We're simply going to ask the jurors to make reasonable inferences from the connection alone. So to the extent the court wants to preclude the Commonwealth from saying there's evidence that he left it in her trunk, we agree. We're not going to argue that. But we should be entitled to allow the jurors to make reasonable inferences based upon the substantial connecting links.
All right, Mr. Sullivan, bearing in mind what the Commonwealth would intend to argue and what they will not be arguing as to Alcorn personally putting that in the trunk or owning the weapon, what do you say?
Then mention of Alcorn seems not relevant. We would also push back on the claim of substantial connection to 114 Lake. I believe Ms. Mercado testified and said she didn't know the name but recognized the face and saw him twice in the home. But the larger notion is, does everyone who has been in 114 Lake Street several occasions have some relevance to this case? And I'm struggling to understand what the relevance to that would be, except to somehow confuse or mislead the jury.
All right. The motion in limine is denied to the extent it seeks to exclude any mention of Alcorn. I think it's more appropriate to hear the arguments if the Commonwealth goes beyond what would be reasonable to permit the jury to infer. Then I'll hear an objection. I will rule at that time. But I think that Mr. Hagan has articulated some acceptable grounds for at least referencing him. He is the connecting link between Ramos and the defendant's relatives. I have defendant's motion in limine to exclude tattoo testimony. I take it this is more a motion to strike the testimony. Let me hear you on that, Mr. Sullivan.
Correct, Your Honor. It's probably better style of motion to strike the testimony. That it's wholly irrelevant, Your Honor. We had testimony from Mr. Nelson, who testified that there were 6 bullets and cartridges in the gun. The majority of the testimony here suggests that 6 bullets were fired. There are a couple witnesses, one witness, Mr. Bradley, who said that 5 bullets were fired, and that was impeached. He was impeached with prior grand jury testimony where he said 6. So the relevance of a tattoo of a gun with 5 bullets in the chambers, when the evidence is that there were 6 bullets expended, strikes me as prejudicial, that there is little to no probative value. What would be relevant and would be probative is a tattoo that had 5 empty chambers and perhaps 1 unexpended cartridge in it. This is the opposite and goes to nothing more than to confuse the jury, and it's highly prejudicial given the testimony in this case and the overwhelming testimony in this case that percipient witness, well, percipient may be the incorrect word, but that witnesses heard 6 shots and not 5.
Some did, some didn't.
But the most I think heard 5 shots. There were some that said 3, 4, but Bradley and only Bradley heard 5, and that was the testimony here, which was impeached by his previous testimony. I do think the stronger argument, though, Your Honor, is that the presence of 5 unexpended cartridges in the chamber that is not evidence of anything. The government's claim
Well,
is that
the ultimate issue is what the defendant intended in seeking that tattoo, and whether or not what he intended, or what one may infer he intended, in describing what he wanted by way of a tattoo and its features.
so then
Evidence is some consciousness of guilt here.
Then may I reference Mr. Nelson's testimony? So Mr. Nelson, on cross-examination, admitted that when Mr. Hernandez came into the shop, he first referenced it's called a gun tree with no specific guns, but just a tree with various guns coming off it. They engaged in further conversation, began looking on the internet, and decided on those guns or not even a gun, it's just a barrel.
I'm sorry, I thought the testimony was the gun tree was to be yet another different tattoo. And indeed, the defendant had said, I'll come back for that, and there were some texts about when are you coming.
So
Did I misunderstand that testimony?
As I recall the testimony, when he initially walked in, he asked for a gun tree. At some point, Your Honor is right, that changed, and he got the barrel on the one shoulder and did say, yes, I'll come back for the tree. This was in response to Your Honor's query about consciousness of guilt. And if you're going to make an inference from consciousness of guilt, then the entire interaction is relevant. And walking in, asking for a gun tree with no specific weapons or so forth, that only once there and in time did they look on the internet and decide about how the gun would look and that sort of thing. And then there's testimony that he told Nelson, gave Nelson certain instructions, but then gave Nelson a license to sort of finish it up. And we presented evidence that it's backwards and so forth, which is, I think, suggestive of the fact that, Nelson used his creative license in putting this together. But again, I'm unsure how the government gets around in this claim of consciousness of guilt that 5 unexpended bullets show that he expended 5 bullets. Distilled to its essence, that's the argument. A picture of 5 unexpended cartridges shows consciousness of guilt of having expended 5 cartridges. This is why the opposite seems to me, that it would be probative of some issue and suggestive of consciousness of guilt if there were 5 expended cartridges and one remaining. So we think, given how the evidence has come in, that it's insufficient to permit the government to argue that this is consciousness of guilt would prejudice Mr. Hernandez, that it's inconsistent with the facts and it's inconsistent with the weight of the testimony that's come before Your Honor.
Okay, Commonwealth.
Your Honor, the Commonwealth's been heard orally and in writing. The Commonwealth suggests that the evidence as it came in is exactly as the court ordered it should come in as far as the predicates that would be required for sufficient. And we request that the motion be denied.
All right, that motion is denied. The defendant's motion for reasonable doubt in related charges to be charged last. Do you want to be heard on that, Mr. Sullivan?
No, Your Honor, we submit on the papers.
Okay, I'll consider that. All right, Commonwealth, do you want to be heard on your request for instructions at all?
Not unless there's any specific questions, Your Honor. I think they're fairly comprehensive, and certainly some of the more general instructions, recognizing Your Honor has the versions that he's given before and may not track these exactly.
All right, now, Ms. Anderson, you're using autocorrect. And so when you refer to specific intent as involving contemplation rather than, do you know what happens when you type reflex?
I do not.
It autocorrects to rather than reflection, so that it reads specific intent is contemplation rather than reflection. I know that because I've made that error in past instructions, so you might want to check your templates.
Will do.
It's on page 28 of the instruction you submitted, and other than that, the instructions you provided, I think, track the model instructions and track many of the standard instructions.
I did note for counsel, I put the wrong name for the extreme atrocity cruelty victim within the submission. It's correct on the chalk, but of course that should be Daniel D'Abreu.
Yes, as I would intended, I will instruct first-degree deliberate premeditation as to both main victims, and then instruct the jury that there is a second theory as it relates to Mr. D'Abreu, and that is that his killing was committed with extreme atrocity or cruelty, and that the jury should consider that as a separate and distinct theory, and should consider both theories of deliberate premeditation and extreme atrocity and cruelty as to Mr. D'Abreu, and the law requires the jury be unanimous as to the theory of, in this case, first degree. So I would intend to have the verdict slip reflect as to Mr. D'Abreu what theory or theories the jury finds have been proved beyond a reasonable doubt. Mr. Sullivan, do you want to be heard on your request for instruction, sir?
We do, Your Honor, and we do have several objections to the government's instruction.
Happy to hear them.
Present. So with respect to, there are a few Scribner's errors, which I won't go over, I just mention our substantive objection. To number 7, the no speculation. The second paragraph includes an express reference to Alexander Bradley and Tanya Cummings Singleton, who are alleged to have been involved in the events of July 16, 2012. The government submission reads, we move to strike that entire second paragraph as the instruction for third-party culprit evidence will be sufficient to guide the jury with respect to how they should view any other people mentioned in this case.
All right, I have not included that paragraph and would not.
Very well. Number 10 is the nature of proof, Your Honor. This, though not mentioning Mr. Bradley by name, I'm sorry, it's on page 10 of the government's. While not mentioning Mr. Bradley by name, this is another, I'll call it anti-Bradley instruction.
All right, well, let me tell you, I do have proposed, I have a third-party culprit instruction. That is a time-honored way of introducing a defense. The jury may consider it, but the Commonwealth is not obligated to prove no one else committed this crime beyond a reasonable doubt. The Commonwealth's burden is to prove this defendant committed this crime beyond a reasonable doubt. So to the extent number 10 is a separate and distinct instruction, I would not give that, but I'd give the instruction about third-party culprit and the Commonwealth's burden as part of that instruction.
Very well. Number 12, cooperation agreement. We are fine with the substance of this, except to say that we would broaden it to immunized witnesses and include all witnesses who received immunity. This is on page 11, number 12. At present, it only references Mr. Bradley.
All right, I, in my draft, have it in two sections. First, referencing Bradley testifying under a cooperation agreement, and that under those circumstances, the witness's testimony should be examined with great care and caution, and they should consider whether the testimony is affected by any interest in the outcome or any benefit that he has received or hopes to receive. And as well, you should also consider the fact the Commonwealth does not know whether the witness is telling the truth in his testimony. That's determination you, the jury, must make. And then a number of witnesses, including Bradley, testified under grants of immunity. The other witnesses, as I understand them and recall them, included Cheyenne Jenkins Hernandez, Tyrone Crawford, Jarrell Pierre, and Oscar Hernandez. And then instruct where a witness testifies under a grant of immunity, you should examine that witness's testimony with great care and caution. The Commonwealth's proposed instruction did not include, but I think it's appropriate to add, that under Massachusetts law, a defendant cannot be convicted based solely on the testimony of an immunized witness. There must be some corroboration of that witness's testimony as to at least one essential element of the charged crime or crimes. Is that satisfactory to your concern?
Without having read it, yes. I'm just looking at our immunized witness instruction. I don't know if the court mentioned Jennifer Mercado as having received immunity.
I did not. Was she immunized?
No, Your Honor. In the grand jury she was, but not at trial.
I didn't issue.
And the same is true for the other two, Wilcox and obviously Tanya Cummings Singleton did not testify.
Wilcox was not immunized here.
Yeah.
Only in the grand jury.
She was never immunized. That is for Wilcox.
All right.
All right. The next is consciousness of guilt, number 14, Your Honor. In the specific instances that the government lists, we make several objections. First are to the characterizations as argument. For example, the verb hid the Toyota 4Runner. These are determinations that the jury should make. We also object to dispose of the murder weapon and his cellular phone. And for these reasons,
Let me tell you the language I would propose.
Very well.
I've written, some evidence was presented regarding defendant's activities or conduct after July 16, 2012, to include garaging the Toyota 4Runner at 114 Lake Ave in Bristol, disposing of certain items and obtaining tattoos depicting cylinder of a revolver, as well evidence that the defendant changed his cellular telephone, spoke to Brooke Wilcox, and obtained a tattoo of muzzle. So those would be the words that I would use. I don't use dispose or hid.
I thought I heard disposed, no? Dispose of the cellular phone?
Yes.
Dispose of certain items?
I did, disposing. Yes. What word would you suggest?
That is something that doesn't carry that characterization. Certain items were not uncovered. I'd have to think about that, Your Honor. We do object to the verb disposed.
Well, I don't think you'd like concealed any better.
I go with the first one, if those were the options. But withheld or failed to retain.
Well, I don't like withheld.
Failed to retain.
Commonwealth, do you have any less pejorative term?
Perhaps discarded, and certainly it's right in line with dispose.
Mr. Sullivan? Discarded?
Indulgence.
Abandoned? Annihilated?
No longer possessed.
All right. I'll think about words. It seems dispose in the context of the instruction probably makes the most sense, but I'll consider any of the language you want to suggest. All right, anything else with regard to that instruction?
No, Your Honor.
Okay.
Um, 16, that saves us a lot of time. 17, rather, the joint venture. 18, Your Honor, the extreme atrocity or cruelty. We just ask, Your Honor, to hold that your ruling in abeyance until our expert has testified. The medical examiner was impeached with her own documents in terms of the length of time that Mr. Abreu lived after the shooting, and we expect to put on evidence as well that would suggest that there's not even a prima facie case for the extreme atrocity or cruelty. So we'd ask Your Honor to hold that until.
Let me just say, on the evidence as I have heard it to this point, I would include it, construing Massachusetts law, I suppose in part on the medical evidence, but I think more based on the testimony of individuals at the scene referencing Mr. De Abreu gasping for breath, breathing, trying to talk, having difficulty breathing, and then expiring and being diaphoretic through the course of that. So it seems that those acts, or that testimony regarding Ms. De Abreu's last moments, qualify under our cases dealing with extreme atrocity or cruelty, separate and apart from what any pathologist may tell us, unless they tell us that pathologically none of that could have happened.
Well, I understand that, Your Honor, and we think that we're going to elicit certain testimony that suggests that whatever it is, those lay witnesses saw something biologically different was going on. So we just asked
Okay.
Your Honor to.
Well, understand that it likely will be bring it to my attention after your expert as to why it ought not.
Very well.
Okay.
Number 21, unlawful possession of a firearm. We would ask that the specific firearm that the government claims is a murder weapon be added to this charge.
It is added in the instruction. It is referencing the .38 caliber Smith & Wesson.
Yes, Your Honor.
That's the gun at issue.
Yes.
So I will instruct that this count references that weapon. Does that satisfy your concern?
We do. So in our proposed instructions, we say essentially a 1913 Smith & Wesson .38 caliber revolver, serial number, and this is the serial number 212682, and that's our request, Your Honor. There's been some claims, at least in sidebar and so forth, by the government that perhaps other weapons are in play. They elicited a prior bad act, a different and unrelated gun that was found months later in a drawer in Mr. Hernandez's home. And we just want to be clear that
let's think about it now. It doesn't necessarily have to be the Smith & Wesson, I suppose. It has to be the weapon that was possessed and used on July 16 on the corner of Shawmut and Herald. And the Commonwealth alleges that is in fact this Smith & Wesson based on Detective Camper's analysis. It really need not be, so long as whatever it was qualified with the legal definition of firearm. But it could not be, say, a weapon about which we heard testimony in Florida. It could not be, separate and apart from the shooting, a weapon in the kitchen junk drawer, or any other weapon that was seen at any time. Similarly, to the extent Bradley sold the defendant a different gun, it could not be that gun. Does that sound right to you?
More or less, I guess if it's not the gun that the government alleges ballistically matches, then we'd move to strike all of the ballistics testimony. It seems that the government has to make a choice, that they're saying that this is the gun that ballistically matches and this is the gun that Mr. Hernandez possessed, but to leave open for him having possessed some other gun that caused the death would be inconsistent with the witnesses that they sponsored. And if they have a belief that that it's some other gun, then they should not rely on that testimony.
Well, except the jury could find that, in fact, Mr. Debreo and Mr. Furtado were killed by means of bullets. Those bullets came from a gun. The gun was capable of firing because it did. And based on the description of the size of the gun, that it would have a barrel length less than 16 inches, without regard to it being a Smith & Wesson. Ms. Anderson, do you have some thought, or are you exercising?
Your Honor, the indictment does specify a .38 caliber revolver, and I think that would be fair to track into the jury.
Okay. Mr. Sullivan, that controls it then. The language of the indictment is what you're advocating for, and I will give that.
Very well, Your Honor.
With
Okay.
nothing further, just the .38 caliber revolver.
All right.
We submit on the record on that, Your Honor. Those are all the specific objections we have with respect to the government, and Your Honor has our submission, and we have specific language with respect to several of these issues, and we ask Your Honor to consider those as well as you're putting together a set of instructions.
Well, tell me what language in particular you want me to focus on. Because this is 39 pages and it was not filed as ordered, so I haven't fully read it all. But what in particular do you want me to focus on?
Court's indulgences. Right, so, Your Honor, we'd ask Your Honor to obviously review, which Your Honor will, the entire pleading. Third-party culprit evidence number 24 is something that we'd like Your Honor to pay particular attention to. 25, conclusions as to third-party doubt, Your Honor.
I'm sorry, page 25 or?
Number 25, number 24, and number 25 are the third-party culprit instructions. As well, and again, this is not to the exclusion of others that are good, that we think are important. Number 16, the tattoo evidence and how that should be viewed. I think we discussed immunized witnesses already with respect to Your Honor's charge. All right. So if I can do this in a little more of an ordered manner, Your Honor. So I'm referencing the charge numbers, not the page numbers. So number 7, number 9, number 10, number 11,
Yeah.
numbers 16, 19, 21, 25, 26, 28, and 30. And yeah, 22, there's a Scribner's error, I should point out. That's one as well. It should be labeled mere presence, but if Your Honor will look at those specifically, we think that they are additive and provide important information for the jury.
All right. Commonwealth, do you have any position with regard to the defendant's proposed instructions?
Your Honor, there are a number that I would object to on the list that I just heard. At a minimum, numbers 25 and 26, I don't know where those come from. One is the third party, but Your Honor has mentioned that you have an instruction already along those lines, so I'm not sure that we need to belabor the point. I noticed the defendant requests a Bowdoin, so-called Bowdoin instruction. I don't think that that's necessary, but certainly Commonwealth versus Williams is the case there, where it's certainly not error not to give the instruction.
Well, except that in the context of some of the missing or destroyed or discarded evidence, I think I've already indicated that likely I would be giving a Bowdoin instruction as a remedy in lieu of dismissing indictments. So I am giving a Bowdoin instruction.
Certainly.
So-called.
There is the defendant's request number 19 on page 26 is for missing witnesses. I don't believe that it's an accurate state of the law as far as what the predicates are for obtaining a missing witness instruction or here an absent witness instruction. And so I don't think any missing witness instruction is appropriate in this case. As I found, the 4 prerequisites are set out in the Mass Guide to Evidence, section 1111. They do not track what I'm seeing here, and either way, I don't think that the predicates are met for a missing witness instruction.
Okay.
I note that the reasonable doubt instruction the defendant proposes doesn't track Russell, so I would urge the court to use the language recently set up by the SJC.
Russell is defining moral certainty.
I believe so. It just changes that modern Webster language just slightly. And it was included in the Commonwealth submission. Yeah, Russell at 470 Mass, 464 from 2015.
It's the new language of moral certainty means the highest level of certainty known in human affairs based solely on the evidence.
Correct. That one sentence.
Yeah, boy, that's helpful. Okay.
We would object to the instruction on tattoos the defendant proposes. I'm not sure I understood the instruction on unanimity. It's at the page 38 of the defendant's submission, number 29. Again, I'm just not sure where that came from, and I just found it confusing. And I don't believe number 30, the separate submission, is warranted. It seems to be an accessory after the fact type instruction, which is not one of the indictments here. And so it's unsupported by the evidence, and the rest of the charge will cover. I think what the concern is here is that if the Commonwealth doesn't prove the defendant's guilty of murder beyond a reasonable doubt, the jury has a duty to acquit. So I don't think that a separate instruction on post-crime assistance is necessary.
Okay.
I did note that neither side submitted an identification instruction, and I don't think that one is necessary, but I know that Your Honor is keen on that issue, so I don't know what you would propose.
Mr. Sullivan, do you want to be heard on that?
We don't think it's necessary. There haven't been any identifications in this case. Except for Mr. Bradley, and we don't contest that Mr. Bradley knows Mr. Hernandez.
Well, there have been descriptions, and we've talked about this before. It was subject to one of the motions in limine. And the SJC has given a great deal of focus to the issue of identification, crafting fairly exhaustive instructions in Commonwealth versus Gomes and some of the other cases that have come out since then. And at least Commonwealth versus Franklin suggests those principles would apply to descriptions as well. I'll be happy not to give it. It adds about 8 pages to the instructions. But if the defendant is not requesting it, I do think Mr. Sullivan, the SJC has conditioned its requirement for specific identification instructions to a request. So, no request?
Well,
I'm not talking you into it.
in an abundance of caution, Your Honor, and we don't think one is harmful. So in an abundance of caution, yes, we'll formally make the request.
All right. Anything else?
Not on behalf of Mr. Hernandez.
Okay, thank you.
Actually, I do have something, if I may.
Not on the charge.
No, I just wanted to clear something up for the court. As to the timing of the defense instructions, I took what Your Honor said in
The timing of what?
the defense submitting our instructions. I took what the court had told both lead counsel in chambers seriously, and for that reason, I made sure that Mr. Sullivan was fully aware of every single document that was being submitted. So for that reason, we delayed the submission of what Mr. Leontire was preparing, and that's the reason Your Honor got the instructions late.
I'd ordered that it be delivered at 4:30. At 6:45, I still hadn't received it and decided it was time to go home. And the downside is I'm not familiar with your precise language because I didn't receive it until too late. So it does slow things down. It slows my ability to give you a written copy of my proposed charge. And I can't do that until I've looked at all of your language. So ultimately, you folks are the bear the loss, I suppose, of looking at the language I will be using. All right. Is there anything else we should be doing today?
No, they were unable to find the exhibits, but they've replaced them.
All right. I'm told, counsel, you all have reviewed with the clerk what exhibits we have and which exhibits we're missing, and 2 substitute exhibits for 249F and 344 have been submitted. Is that both sides in agreement on that?
Yes, sir.
And do I understand, Mr. Sheehan, then we are complete?
Correct, Your Honor.
Okay. All right. Mr. Leontier?
Thank you. The court received today, Your Honor, received a letter from Sandra Amato, one of the witnesses who you may recall.
I have just been handed it. Who's writing me a letter?
This is the witness that the court allowed the ex parte order for service, electronic service.
Yeah?
And he doesn't feel that he should testify. However, he makes no legal argument except at the end with respect to, our argument was that even overseas, the Massachusetts resident, he's subject to Massachusetts service requirements. They simply cite some case where an individual moved to Sweden and was no longer subject, but this is a different situation. We believe he is subject, and we'd simply like a report from the court that he is subject and expected to testify.
Just to be clear, I received that letter via email from the fiscal law attorney stationed in Kuwait, who prepared it for the witness.
But it's signed, the letter's signed by the individual that we've been attempting to obtain, and believe we have properly obtained pursuant to the court order service. But he's saying, for the foregoing reasons, I ask you to quash the April 3rd, 2017 subpoena for me to testify. And we're just asking that the court respond that it denies the motion.
All right. Well, I don't know anything about Army regulations regarding service of process, and I am not familiar with the provisions of the U.S. Code relating to service of members of the military based on their domicile or residency. So I think I got to spend some time reading this letter, and to the extent you want to brief the issue of the propriety of service in the manner in which you have attempted to serve Mr. Amato, in the end, does it make any difference? If I find that it's valid service, do you expect he's going to be here tomorrow morning?
We were attempting to do and they have the capacity, they've already notified us, to do a Skype, to Skype them in, the video testimony.
And under what provision of our rules of criminal procedure is Skyping the testimony of a witness permitted?
Well, it's the same thing as, it's totally within the discretion of the court, but it's the same thing as teleconferencing someone in or bringing them in. I mean, I know the court even has the capability to do what they do.
The only exception, as I understand it, relates to taking a deposition to perpetuate testimony is at Rule 47. And that's a precise and specific rule. I
have used that procedure on medical experts
in what criminal case of the Superior Court?
Civil cases in Superior Court.
The rules of civil procedure are quite different than confrontation issues in a criminal case.
One quick thing before the procedural issue, maybe someone else can address the procedural question, but I just want you to know the objection is not as a result of any military law or anything else. Under military law, they had the right to ask him if he wanted to accept service. He said he didn't want to accept service. That's why we sought the order by the court. However, their objection is as to his materiality with respect to a witness, and he is asking him to be quashed on that purpose.
Let me read what he's written.
Okay.
And to the extent you want to give me some law on both on Skyping in a criminal case and on the enforceability of a subpoena to an active member of the military serving out of country, I'll hear you. And I'm not suggesting you're wrong, I just am not familiar with those provisions of law.
Military base is considered part of the United States, and as a Massachusetts resident of the United States.
Well, you're telling me that.
Yeah, no.
Show me that by provisions, if you would, either of the U.S. Code or Massachusetts law. All right. Anything else that we can do today?
No, Your Honor.
All right. As to tomorrow, we have 3 witnesses scheduled. Any sense of when we may conclude their testimony? Another way of saying, are you folks going to be closing tomorrow or Thursday?
When you say we will be resting tomorrow, preferably, yes.
When? You think you'll rest before lunch?
I don't think so. I think we'll...
Mr. Hagan, you have any sense of that?
From my conversations, I think the parties agreed that we would conclude the case by tomorrow afternoon and close on Thursday.
Well, that's what you'd like, is what you're telling me.
I believe we can do, and it's what we'd like to do.
Okay, and with regard to Dr. Downs, Ms. Kenny Baden, did you make arrangements with Mr. Lee in that regard?
Yes, everything is all arranged, Your Honor.
Okay.
And all the exhibits have been over to...
I'm sorry?
And all the exhibits have been turned over to Mr. Lee, and we've been communicating late.
All right, then I'll see you folks tomorrow, 9 a.m.